Good evening, everybody, and welcome to the latest instalment in the SEN Legal November webinar series. The webinars are being hosted every Tuesday and every Thursday throughout November, live streamed between 7 and 8 in the evening, and they'll be shortly made available on YouTube for you to watch at your leisure. We're joined this evening by Melinda Nettleton, who is our Principal Solicitor and Director, and she's going to be talking about all things related to off-rolling stroke exclusion. So hopefully there'll be some really good content in there for all of you who are having problems with off-rolling or getting admission to the school of your choice. We are very limited on time, so I'm going to hand over to Melinda because she is the woman with the information, and hopefully you'll find it really useful. So over to you, Melinda.
Hello, everybody. Right, now, off-rolling is an issue which is little talked about, but it is basically pressure to move on to another school. And sometimes this comes as a complete surprise to parents, and they're thrown into a state of total panic. Off-rolling is the practice of removing a school from the school roll without a formal permanent exclusion. What it amounts to is getting rid of a parent and child by encouraging the parent to move their child from the school. And it's primarily in the best interests of school, not necessarily in the best interests of the parent or child. In mainstream and particularly high performing schools, this tends to happen before GCSEs. And the view is that the main reason is manipulating the school league tables. There have been a number of well-known cases which received a great deal of publicity. The most well-known is probably St Olave's School in Bromley. That was a case where the youngsters weren't performing as highly in their examinations or in their mocks as the school wanted them to perform, and they thought it might affect the league tables. In that case, a group of parents dealt with the off-rolling of their children by judicial review proceedings under Regulation 8 of the Education Pupil Registration England Regulations 2006. Ignore the snappy title. It basically means that you can't get rid of a pupil unless it complies with Regulation 8. And that applies to independent schools, academies, and mainstream schools. The judicial review was settled without a hearing. That's to say the school promptly gave in. The reason it promptly gave in was it was a complete breach of Regulation 8. It's rather like parking on a double yellow line. There is no excuse. So the judicial review settled without a hearing. It resulted in the resignation of a head and reinstatement of the pupils. But this policy of weeding out pupils not likely to achieve high grades does happen. And the remedy for it is always going to be a quick judicial review, and the school will give in. It has no choice, absolutely no choice, because it is a clear breach of Regulation 8. Many of the cases we come across, because of the nature of our practice, we're dealing with special needs and disability. Many of the cases we deal with are about behavioural difficulties, and the schools start putting pressure on a parent to remove the child. It's presented it's presented to the parents that another school would better suit their child. They have much more provision, they have much more experience in, or alternatively, it's better to move on than face permanent exclusion. But in many instances, this is a total shock to the parents. One of the reasons I think it is a total shock is the traditional approach of teachers who try to persuade pupils to do better by praising them. You did well there, in order to get a better achievement. And once teachers have been engaged in that practice with a pupil for quite a long time, then the result may be when effectively there's an incident where it's the straw that breaks the camel's back, it does come as a complete and utter shock to find out what the school and teachers are really thinking. On many occasions, it's suggested to the parent there's an advantage in moving on to avoid permanent exclusion because it will make it harder to get an alternative placement if their son or daughter has been excluded. You hear this refrain, you won't get another place. Behavioural issues, of course, can be dressed up and made to be more than they were, but it is unlawful to exclude for non-disciplinary reasons. For example, additional needs, special needs that cannot be met by the resources the school has. And that's one of the issues there, of course, is underfunding of mainstream schools and some of the ways in which local authorities are currently funding, which is in turn sanctioned by the DFE and Education's Skills Funding Agency. There is an underlying difficulty on funding. So this regulation I'm talking about, Regulation 8 of the snappily titled Education Pupil Registration England Regulations 2006, applies to both independent and mainstream schools. And pupils can only be deleted from the admission register of the school for the reasons set out in Regulation 8, deletions from the admission register. Every school is required to have, independent or otherwise, an admission register. That's an earlier part of the regulations, and then Regulation 8 deals with how to get rid of pupils off the admission register. I'm not going to go through this in detail. To find Regulation 8, what you need to do is Google the Education Pupil Registration England Regulations 2006 and click on www.legislation.gov.uk. And you then go to Regulation 8 and you can see the full text, which is horrendous. 3 pages, dense type. If you want to search it, that's where you will find it. But what it basically amounts to is children and young people can be removed from the school roll following the pupil's death. Well, that's logical. Their disappearance, if family and child disappear, after a certain length of time, they can be completely removed. Moved to another school, that's obvious one, primary to secondary, or parents have moved house, and for home education. And then there are a number of other less common situations listed in Regulation 8. What it does not do is permit the weeding out of pupils unlikely to achieve high grades. That's the most traditional form of off-rolling. But it equally does not permit the weeding out of high needs pupils, that's pupils with special needs. It does, however, permit the removal from the school roll following a permanent exclusion. Get yourself permanently excluded, yes, they can remove you, but you have to go through a process to be permanently excluded. Permanent exclusion doesn't take effect until the appeal procedures against permanent exclusion have been finished, or the parents have said they don't intend to bring an appeal, or the time for bringing an appeal has expired and no appeal has been brought within that time, or alternatively, the parents have brought their appeal within that time and it's either been decided or it's been abandoned. Okay, so procedures have to be gone through. Just taking a child off the roll is not allowed. So the question then arises is, well, is a formal exclusion preferable? Is there any strength in this? Well, you won't get another place. Other schools will look down on you. Well, on a purely legal, lawyer-like, legal, evidential basis, a formal exclusion is immensely preferable because a formal exclusion to a lawyer presents a wonderful evidential opportunity. I've already said in many of the cases we deal with, the suggestion that the child should move on for whatever reason come as a shock. The issues have been underplayed because the school has been following the traditional method of encouraging a child to do better by performing the things that they have done well. And so it's the case that the parent hasn't got the whole picture of what's been happening. However, an appeal against exclusion generates witness statements from staff, witness statements from other pupils, and they generally provide some fairly blunt evidence that a parent can then turn around and use about the level of provision that is in reality required. The tendency is, if a parent just moves their child, local authorities then minimize the difficulties and say, well, it wasn't really that bad. If you've got the evidence of how bad it was, what the problem was, you are then in a much better position to argue that greater resources are required. So an appeal against exclusion is useful in terms of obtaining evidence. For the parent, it may well be stressful, but evidentially, if you're planning to go on to an SEND tribunal or hope that you can persuade the local authority that that route isn't necessary and they should increase the provision anyway, it provides you with a great deal of evidence. So an exclusion is an opportunity to gain valuable free evidence. You need to look at the road ahead. Where are you going? What do you want? How am I going to obtain it? And evidence is always important. The SEND tribunal is evidence-led, and an exclusion is an evidential opportunity to secure better and more appropriate provision. If your object in insisting on you're going to have to formally exclude is solely to obtain evidence, once the school's case, their witness statements and what have you have been sent to you, you can abandon the appeal if you don't want to go through with it. That's the logical thing to do if your sole purpose was gaining valuable free evidence. And let's face it, if a school doesn't want you, why are you trying to fight to be there? Why don't you go somewhere else that you'll be welcome? That's an alternative view. And you're likely to be welcome elsewhere with better resources. So schools offer this managed move scenario. However, a managed move is not usually going to attract more in the way of resources. Yes, all right, it's a fresh start, but a fresh start isn't necessarily going to address the young person's difficulties. It may well mean that the new placement fails in exactly the same way as the old original placement. Managed moves are fraught with difficulties unless more resources go with them. There is no school with a magic pot of money. We're back to magic money trees. Evidence is something you can use to get better resources that address the difficulties. So is there any truth in the suggestion that an exclusion will make it harder to obtain another placement? Well, the answer to that is no. An exclusion is likely to mean it's easier to get an EHC plan because the evidence exists. If an EHC plan exists, then an exclusion is an opportunity to increase the provision in the EHC plan and change the placement to something more suitable. An EHC plan must name a placement under Section 43 of the Children and Families Act 2014. Sorry, I've got that wrong. An EHC plan must name a placement, comma, and under Section 43 of the Children and Families Act, the school named is required to admit the child. That is a legally enforceable obligation. It doesn't matter whether the school doesn't really want to admit you. It doesn't matter whether the school is over the county or borough boundary. Once it's named, the school has to admit you, with one small exception, that is very, very rarely used, and I'll come to that later. So this is an illustration of change. It's called the learning pit, and educational psychologists use it. The point that I'm making at the very top of this slide is that failure equals success. The system operates on the basis that the greater the failure, the more success in achieving resources to meet your child's learning needs you're going to have. So that's why the equation is failure equals success. And you're therefore looking for examples of failure to maximize your success in achieving provision for your child. So if we look at this learning pit illustration that educational psychologists use, you've got the old status quo on the left. You're bombing along quite happily. The teachers are praising your child and saying, oh, you did that well, you did the other well, to encourage them to do more. However, the foreign element intervenes. They basically, for some reason, snap. There's a straw that breaks the camel's back. You fall into the pit, there's resistance. Surely my child would never, or whatever. Your feelings are thrown into total chaos. At the bottom of the learning pit is the transforming idea. Now, the transforming idea is what I'm putting to you. Manage your evidence. Failure equals success. Get the witness statements if you can bear to go through with it on a formal exclusion. Formal exclusions aren't for everyone, I admit. Sometimes the situation is just totally impossible. But nevertheless, it is worth considering. And then the slide continues to show getting out of the learning pit, a new status quo when you've used your evidence to get a new and better and more suitable provision that isn't as stressful for yourselves and your child and actually properly meets their needs. So the whole climbing out of the learning pit, that may well involve negotiation with a local authority, possibly an SEN tribunal, but the new status quo should deliver you something that's better than what you had before. Okay. Now, Regulation 8.1d is home education, and many children and young people with ASD and ADHD and other behavioural issues move to home education, otherwise known as education otherwise. The downside is if you're seeking an EHC plan or different provision in an EHC plan, if you've basically given up on the school, moved to home education, the local authority are likely to regard it or argue it was a voluntary option, and they're likely to dispute that the previous placement failed. So that is why I am saying that the evidence of an exclusion is extremely useful to you, because the sort of bluntness you get in witness statements for an exclusion hearing does not occur in any other point in the education system, in my experience. It's only then that is told absolutely like it is. Regulation 8.1d, the home education transfer, only requires the parent to inform the schools. Many local authorities seem to think that they need to be contacted. The regulation does not say this. I think what they get confused with is special schools. Special schools are different. And Regulation 8 also says that if a pupil attends a special school, then the local authority's consent is required to go for home education. Although there is an appeal to the DFE, Department for Education, if the local authority refuses consent. So it's not quite as they try and portray it to parents. Regulation 8 applies to local authority maintained schools, academies and independent schools. Independent schools must not discriminate in the way in which they admit and treat students. In this situation, though, an independent school it would be an Equality Act claim for disability discrimination in the SEND tribunal. Yes, disability discrimination cases can and are taken up against independent schools. However, disability discrimination is dealt with in a series of separate slides already on our website and YouTube channel, so I won't deal with that again. So the next question is, can they force you into a special school? Well, the answer is generally no. Generally no. Parents have a qualified right to a mainstream education. You're entitled to choose a mainstream school, maintained or academy, and the local authority is legally required to name your chosen school in Section I of your EHC plan under Section 39(4) of the Children and Families Act 2014, and also Section 33, which I refer to in the next slide. In order for a mainstream school to refuse your placement, you have to, they have to demonstrate it is unsuitable for the age, ability, and aptitude or special needs of your child. Okay. Or the placement would be incompatible with the provision of efficient education for others, that's others in the school, or the placement will be incompatible with the efficient use of resources. To rely on the argument of incompatibility with the efficient education of others, both the local authority and the school must prove that there are no reasonable steps that either of them can take to prevent the incompatibility with the efficient education of others. So if it's a case of slinging more resources at it, moving a porter cabin, they're all steps that could be taken. It's very, very difficult to get out of naming a mainstream school if that's what the family want. If that's what the family want, a mainstream school on their EHCP, very, very difficult to get out of it. If a school is named in Section I of an EHC plan, the head teacher and governing body must admit the child. It applies even if the school named is over the county or borough boundary in the area of another local authority. If a school has been named and there is a disagreement between the school and the local authority, and they're at loggerheads over your child's placement, the school can apply to the Administrative Division of the High Court to set the EHC plan aside on the grounds that the local authority's decision is irrational. This happens rarely, but it does happen. There is a reported decision called Medway, but usually the matter is settled before the court hearing happens. Local authorities currently naming mainstream placements and telling schools that they will have to wait and hold the pupil until a special school placement is available. I am not sure that parents are always told this. In fact, I'm quite sure they are not always told this, because sometimes when we do data protection act searches, having been instructed to run cases to the SEND tribunal by parents, we've found correspondence to this effect, and the parent knew nothing about it at all. The special school can be already full. It can have exceeded its maximum number, but you can still get a place there. The fact that it's full is not an answer. The question that has to be answered is what additional provision is needed in the EHC plan so that that particular special school can take another child. This is an issue of expert evidence in the SEND tribunal. You need an expert, you need an independent educational psychologist, and that independent expert needs to visit the school concerned and work out what is needed so that the school can take an additional pupil. It can be done, and it is done. The tribunal, of course, can also name independent special schools. The local authority's special schools may be full, they may be inappropriate in terms of the mix of children, but the tribunal can name an independent special school. But the tribunal is a judicial body. Its decisions are based on evidence, and you need to obtain evidence from a suitable expert about what is needed. And you really, really can't do this one on your own if you are squeezing yourself into an already full school. The SEND tribunal has the power to order the naming of a school, even though it says it's full. Normally, in these circumstances, Section F will be amended to increase the provision. That will in turn increase the funding for the school. And under Section 43, the school must then admit your child. So your legal remedies, well, if it's a straight Regulation 8, off-rolling because of the school league tables, then judicial review, pre-action protocol letter. In the case I mentioned earlier on, proceedings were put into court, but the matter was simply settled. The school gave in. It's the equivalent of parking on a double yellow line, and you will find that if that's what's going on, it's off-rolling because of school league tables, then judicial review is your answer, and it's unlikely to go all the way to a hearing. The other legal remedies you've got are disability discrimination. That includes independent schools. And as I said before, there is a previous PowerPoint dealing with that, which is on our website and is on YouTube. The SEND tribunal is also your remedy if you want to change the EHC plan, get better and more appropriate provision in Section F, and also a different school in Section I. And that includes independent specialist schools. I hope that helps.
Thanks very much for that, Melinda. Obviously a big subject to cover in a brief PowerPoint presentation. So as ever, we've got some really good questions here actually, to put the flesh on the bones a bit of what you've just talked about, and a good mix of questions across the different topics. So the first question I've got here is, how does Ofsted look at off-rolling, and can they do anything about it?
Ofsted can't do anything about it. Ofsted is basically an assessment of the school, so that is not how you deal with it. The school that was really caught well and truly, although it wasn't the only one, there was another one that got rid of 17 girls one year. The local authority held an inquiry into it and described the loss of the pupils as collateral damage. That's being a bit over competitive, but no, Ofsted isn't going to do anything about it.
Okay, so that's not the way to go.
Generally speaking, Ofsted is on that sort of issue a complete waste of time.
The next question, it's quite a broad one, and there's not much information, but it's what if the school exclude unfairly to avoid off-rolling?
Well, that's absolutely fine. Do you actually want to keep your child at a school where they're unfairly off-rolling via exclusions? You know, do you really want to keep your child somewhere where they're not welcome? My proposal is that you embrace the change, you take the maximum amount of evidence, whether you regard it as unfair or not, even if it is totally unfair, and in your heart of hearts you disprove it. Nevertheless, it is a tool to get greater resources in another placement out of the local authority. And it may well be that you get a much, much better and much more suitable placement where your child can learn and thrive, and you're not stressed out all the time. You know, you have to pick your battles in life. So that is my suggestion. Why worry about it? Welcome it with open arms and use it.
This was quite a lengthy one as well. I'm going to chop and change it a bit just to, I think, so that it makes more sense. So this parent's written in, their child is refusing to go to school for needs which the parent says are relating to their special educational needs, which the school don't accept. The school have now told them that they can off-roll their child because they're not attending. Are they able to do that?
No. Because the child hasn't moved to another educational setting. The child has not disappeared, so it doesn't come under that one. So no, they can't. If they want to get rid, they've got to exclude. And exclude on the basis of persistent absenteeism and one or two other things. I'd start opening negotiations with the school and saying, well, you know, if you want to get rid of us, why don't you start formal exclusion proceedings? That way you're armed with evidence up to the teeth to get something more appropriate that the child will go to. I mean, children refuse to go to school for a variety of reasons, and usually the subtext is the placement is completely inappropriate, whether it's because your child is severely dyslexic and they haven't got the amount of specialist dyslexia teaching, and it's like going to school is like continually putting your hand in a pot of boiling water, or it's ASD or ADHD, anxiety levels mounting, and it's all going really, really horribly wrong. The bottom line is the school is not appropriate.
Understood. This one's actually about off-site provision. So my son's school want to move my child to an off-site provision due to his behaviour. Can they do this?
Well, it depends on how the off-site provision is framed. If it is being framed as totally and completely an integrated part of the school, well, okay. Yes, they can. But if it is in fact a little separate satellite they've set up, which is more or less a school on it, all on its little own, with its own school role, then the answer is no. It needs looking at very, very closely, that one.
And just this isn't actually part of the question, but I think it's a good follow-up just for parents' knowledge. What can they do in those sort of circumstances, Melinda? What would their challenge be if the school was trying to do that?
Oh, it's an unlawful off roll. So you're doing a pre-action protocol letter and threatening judicial review. And in the letter, you should be inviting the school to exclude using formal exclusion mechanisms and having a hearing. Whether you actually want to go through the hearing is another matter. I mean, my personal preference is to grab the evidence and run.
There's a question here. It's a little bit off topic, but I'm going to ask it anyway because I think it's quite relevant with regards to the type of schools that you can request be named if you are moving on. So this parent, they have found what they think is an appropriate school for their child. It's registered as a non-maintained special, but the school themselves are saying that being non-maintained special is the same as being independent, and that therefore there's no duty to admit. Is that correct?
I'd like to look at it very, very closely before actually forming a view on that one. Okay. Non-maintained special usually means independent, but it's perfectly possible that some free schoolers possibly got a slightly mixed idea of its status. I never take anything at face value. I always have a good dig because people have all sorts of misunderstandings and they think things are right, and when you look at them, they're not.
Yeah, never a true word.
So I would certainly have a good dig myself.
Oh, this is about home education. So my daughter's school place is broken down. I've decided to home educate. The LA have asked for several meetings, want to see my lessons, samples of work. It's very invasive and intimidating. Do I have to do it?
The answer is no. No, you don't. You don't. It's rather like placing your child at Eton. Do they actually expect samples of work from Eton? No, they don't. They are basically interfering. But on the other hand, you refusing just outright like that could result in child protection proceedings. So it does need looking at very, very closely. Again, it's the sort of thing that I might well do a solicitor's letter, suggest a solicitor's letter for, to make them back off and ask them, okay, where is your judicial authority for requiring all of this? Or in the alternative, which piece of legislation or regulation are they referring to? Because basically it doesn't exist. It's the local authority assuming powers that they haven't got again. But you do need to be careful just in case they do start child protection proceedings, because sometimes they'll threaten that. and you don't really want to go there.
No, agreed. This next question, it's about a child who's in the process or will next year be moving to primary school. So they're going through the phase transfer stuff. They've been looking at various schools. The child has behavioural needs, which they think are linked to sensory needs, but that's all a bit unclear at the moment. All of the schools that have been consulted in respect of the EHCP in the same local authority area seem to be sending back the exact same almost template letter, 1 page long, saying cannot admit because can't meet needs and inefficient with the education of other children. Is this lawful? Is there anything the parent can do about it?
Well, it's perfectly lawful to say that they can't meet needs for those reasons. But you could have a meeting with the local authority and demand that they amplify it and have a good look at section 33 and say, well, actually, are there no adjustments that the local authority could make in terms of more resourcing, putting in a porter cabin, one-to-one? I mean, you really do need to look at the wording of section 33 very carefully and rub their noses in it. A school has got a very high threshold to cross if it's going to say no. And that very high threshold means that it's got to be completely and utterly irrational. Now, we have proved irrationality on occasion, but it's very, very rare because it's such a high threshold. And you should be using it as a way of achieving better provision for your child. Whether if you're absolutely devoted to mainstream, you want a massive injection of resources into your favorite one of the local schools, or in the alternative, whether you're actually thinking, well, my child is bright, he is not a match for the cohort in the local special schools, and therefore what we really want is a placement in the independent special school sector for high functioning pupils with behavioural difficulties. You know, you have to bear in mind that some of them are in the independent sector are very good and are geared to getting children into university. There's one in particular I can think of that's actually aiming at special needs children at Oxford and Cambridge. Quite an impressive outfit, actually. So they do exist. You really have to think about carefully what you want. As I say to parents who talk to me in this situation, well, if I could wave a magic wand, what would you actually like me to deliver? Because once I know what a parent wants me to deliver, I can set about working out how to get there. It's rather like Mouse said, a journey starting with a single, journey of 1,000 miles starting with a single step. You've got to know in which direction to put that single step, haven't you? So you need to work out what it is you want, what you need to achieve, and then you set off and gather your evidence in terms of achieving it. So in terms of the specific question that all the schools are saying no, and it looks like a pro forma, well, do I actually want any of them in the first place? I mean, you've got to make that your mind up on that one first. And then if there's one that you really, really want, then you start testing it in terms of section 33 of the Children and Families Act. You can even threaten to judicial review both school and local authority for failing to comply with section 33. They've not taken reasonable steps to prevent incompatibility with the efficient education of the other children. I mean, it usually boils down to resources. It's always money.
Absolutely. I think it's just worth plugging there as well. We do have a webinar coming up hosted by Richard Nettleton, and he's going to be talking about non-tribunal routes of redress, including judicial review. So all of the judicial review stuff Melinda's talked about there, Richard will be going over in more detail. That's all of the questions that we received for the webinar, Melinda. Thanks so much for answering those. I'm sure that they'll be really helpful for the parents to ask them. And all that goes to say is thanks to Melinda for her time, and to all of you for joining in and for watching us at home. As ever, we've got lots of webinars coming up. If you have any questions that you want answered, do feel free to submit them via Facebook or Twitter, or our website, or of course you can attend on the night and ask through the Zoom chat function. Thanks very much. Bye.
Bye.